Thank you for the warm invite, Dr. V.R. Sampath. Honorable Justice Valinayagam, dignitaries on and off the dais, a warm good afternoon. It's indeed quite a tough task to be a speaker in the session immediately following lunch, but I hope to keep it brief as possible. So the topic that I've chosen for presentation today is competition law and issues in cross-border transactions or extraterritoriality. In the current economic environment, globalization has paved way for international trade. Mergers and acquisitions play a vital role in the transnational business scenario. With the rise in M&A deals globally, issues relating to anti-competitive practices also arise. Now, this violation of anti-competitive practices is in terms of abuse of dominance, formation of cartels, combinations, etc. So the standard of laws of a particular nation govern the laws of that particular state. Whereas when there are undertakings such as Apple or Samsung or General Motors, they have their products throughout the globe. So their products are sold globally, as a result of which nations frame their own laws to combat anti-competitive practices. Now, coming to the aspect of global presence of companies, the violation or anti-competitive practices of companies need to be checked upon by the laws of that particular state. Now, this has led to a practice where nations need to cooperate with each other to frame laws to combat the anti-competitive behavior of that particular firm in that particular state. Now, put it simply, any state would frame laws to protect the interest or well-being of its own citizens and its own people. On the other hand, anti-competitive practices of companies or firms need to be checked upon by the company, or by the state in its own jurisdiction. And the main issue is with respect to the jurisdictional aspect of the firms. On a practical note, states do not always cooperate with each other and lead to investigations. The statutory provisions of particular states need to be looked upon on the issue of extraterritoriality. Now, with respect to the context of extraterritoriality of competition law, the much needed R, or the much needed requisite of the R, is to protect the interests of the local people as well as the corporates in terms of combating the anti-competitive behavior of firms in that particular jurisdiction. Now, in the famous Alcoa case, the concept of extraterritoriality was first discussed. The appellate court held that the concept of extraterritoriality can be exercised upon by a state when it has an impact on that particular state. The jurisdiction of a state can be exercised upon firms which have their presence outside the state but has an impact or a consequence in the particular state. Now, this issue of extraterritoriality by a state needs to be looked into not only by that particular state, but also in a global scale, so that the extraterritoriality can be checked upon and the violation with respect to anti-competitive practices can be combated. Now, one of the important aspects that needs to be looked upon to combat such practices by companies is for states to enter into bilateral or multilateral agreements with one another. Now, another important aspect that needs to be studied is with respect to the binding nature of these agreements. Though these agreements are entered into between states, the binding of these agreements are not enforceable. Hence, another issue which needs to be looked upon in these aspects of entering into agreements is to have an international regime for combating these practices. Now, the WTO, as you all know, has a global presence and is an active body in protecting the trade policy or promoting international trade as such. So an international body similar to WTO is required in the aspect of competition law to solve this aspect of concurrent jurisdiction and cross-border mechanisms or cross-border transactions in combating this anti-competitive behavior of firms worldwide. Thank you.